Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. So we received an interesting inquiry here, actually a few inquiries on our YouTube channel. We're responding to our questions here. Let's see. First question has to do with not knowing about the consequences of a DUI. Let's see right here. Espinoza 805 Full asks us, when I was 18 years old, I got a DUI. I went to court and I pled guilty. I paid the fine and went a year without driving. After 6 years, I applied for a license and they gave it to me. All right. Time passed and I lost it. Now that I went to the DMV to get another one, or a replacement one, they told me I had a DUI and I should go to DUI school. First, I'm going to say hi to Sarah Hamilton, who's watching us right now on our Facebook page. So here's the deal. It sounds to me like you never did your DUI school, and the first time when you got your license back, the DMV, for one reason or another, didn't notice it and just gave it to you. And then when you try to get your replacement license, they realize, oh, no, you never did your DUI school. You have to do it. Well, that's one thing that could have happened. The other thing that could have happened is you did your DUI school, but the private school that you went to never sent proof of completion to the DMV. And this is key right here. Just because you go to a school and finish your DUI classes, your 3 months, 6 months, 9 months, 18 months, whatever it may have been, it's your responsibility to turn over to the court your proof of completion and to the DMV. Don't rely on the school. They're private schools and they do not retain records very well. So you could have done an 18-month program, never thinking that you could drive perfectly fine, and then you discover later on, oh no, the DMV never got proof that you did the DUI school, and the school no longer has proof that you did it. You lost the paperwork, so guess what? You got to start all over again, and you got to do that 18-month school. It's horrific. So number one, keep good records. You should keep them, you really should keep those electronically. You should keep your proof of completion sealed in a safe, or you should definitely have them laminated. Don't just have them like pieces of paper. No, those things are really important. You cannot trust the private schools. And be sure that you yourself has gone over to the DMV to show proof that you did complete your DUI school. Otherwise, you could have consequences down the line. And if they catch you driving on a suspended license, you could get up to 6 months in county jail under Penal Code, California Vehicle Code, Section 14601.1. Regardless, if you would like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates. I'm going to proceed with question number 2. This has to do with false report of domestic violence. Let's see right here. Ms. Susie Vasquez asks, what can I do to remove the charges against my husband? Out of anger, I reported him for domestic violence, but he never touched me. Oh, jeez. Yeah, this kind of thing happens all the time. All the time. You get upset, you accuse your husband of domestic violence, he didn't even touch you. The problem is now you have a big dilemma. I'll tell you what the dilemma is. Number one, you can't just remove the charges because it's only the DA who decides whether or not to file charges against the accused. You would have to go to the DA's office and basically tell them, hey, look, I made this up. But you're going to have a little bit of an issue there, a couple of issues. Number one, statistically speaking, victims of domestic violence almost always want the charges to be dropped. Even though they don't have the power to remove the charges, they almost always want the charges to be dropped. The reason is because they want to maintain the relationship. They believe things will get better, or that things have gotten better, or the person has apologized, whatever it might be. But no, the victim does not have the power to just blow that off. Now, here's the issue. The victim could go to court and say, okay, here's the deal. I made this up. I lied. This didn't happen. She could say that in court. But then the victim's going to have another dilemma. The DA at that point during cross-examination is going to ask the victim, well, are you lying right now? Or did you lie before to the police? In other words, hint, hint, are we going to charge you with perjury? Or are we going to charge you with making a false report? That's a little bit of a dilemma, but let's face it. You did commit a crime in the sense that you filed a false report. That does carry up to 6 months in the county jail. You have to be aware of that as the victim. but I guess you'd say that is the right thing to do. But you're going to have to go to court and basically say that you lied, and the DA could say, no, you're lying now, and could theoretically try to charge you with perjury, or could say, okay, fine, you lied to the police, and they could charge you with making a false report. But that's basically your only way out of it. Regardless, if you'd like to learn more about criminal defense, don't forget to subscribe to our channel. Actually, if you've been accused of a crime and need representation, give us a call for free consultation here in the San Francisco Bay Area, 1-800-862-7677. Once again, 1-800-862-7677. I'm going to proceed with question number 3. This has to do with sexual relationship with my mother-in-law. Oh boy, let's see here. I had problems with my wife, and my mother-in-law treated me very kindly. So much that we started having sex. Oh, jeez. My wife started spying on us and discovered us. What charges can be filed against me? None. Here in the state of California, it is not a crime to have sex with your mother-in-law as long as she consented. As long as you consented, no crime. That's probably not going to fly with your wife, but it's not a crime. Here in the state of California, and I don't believe in any other state, infidelity is not a crime. In other countries it might be, but here, being married has nothing to do with sexual relations. Marriage is strictly a financial agreement. Nothing else. It has to do with money. Nothing else here in the state of California. It might have a little bit more it might have to do with a few more things in other states, but in California, it's basically money. And yeah, so if you have sex with your mother-in-law, she might not like it, but legally, aside from saying, okay, I want a divorce, which is probably coming down the pipe anyway, considering you guys were not getting along. But no, you didn't commit a crime, so no, keep going. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comments section below so that we may respond in the future with more videos for you. And give us your opinions on what you think about this. But if you'd like to, but if you've been accused of a crime and need representation in court here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and make sure to ask your questions. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.